order. Heidi, would you call the roll, please?
David Trenizow.
Here.
Keith Kyle.
Absent with cause.
Christine Brochu.
Here.
Karen Coutinho.
Here.
John Ball.
Here.
Leslie McKnight. Here. Ellen Corneau.
Here.
Ms. Secretary, we have 6 members present. You have a quorum.
Thank you. Hi, everyone. This is quite... does anyone, if you want to like move in, people out there want to, move in. We have a little bit of standing room over here.
Yeah, there's... No.
Maybe a little.
Can we move the table? Yeah, I know. All right,
Mr. Fabian, do I need a motion to have Karen serve as secretary tonight since I'm chairing? And do I need a motion for that, or can we just appoint Karen?
Just appoint.
Okay. All right, I will. So under administrative matters, we have a few housekeeping matters to take care of. So there's a couple things we have to continue. We will be continuing to date certain. McCarthy will be continued, we believe, has requested a continuance till January.
Yes.
So if I could have a motion to continue McCarthy to the January meeting.
I will move to continue McCarthy to a date certain January meeting.
January 22nd.
January 22nd,
Second.
thank you.
All in favor?
Aye.
Opposed? So if any of you are here for McCarthy, that is going to be heard at the January 22nd meeting. So,
Thank you.
sorry.
All right, that's a little bit.
We're gonna take these out of order because there's a couple more continuances. So I want to talk about it. So Skybound Development.
Ms. Secretary, I would maybe wait. I know that Mr. Serta is here, so he is the representation for that project.
Steve.
Mr. Serta?
Yes.
Hi.
I'm sorry, it's very difficult to hear back there.
No,
I apologize.
understood. So Skybound Development, I understand that you're requesting a continuance for that?
Yes, we are.
Okay.
We are working, we heard a lot of recommendations from members of the community, butters. I can speak up, no problem. And as well as some concerns from staff about the condo association. I believe we're compliant, but out of deference to staff and a desire to make friends, we're going to address that. And then we also want to make sure that the board has enough time to review some revisions to the plan set that we've just made and submitted to staff.
The boards and staff.
Boards and staff, absolutely. You guys have a lot on your plate, and your volunteers, and we all appreciate your time here. So I will make that request to move to the next meeting of the zoning board.
Okay, is it January meeting, or is it, do we have room on the?
Yes, yeah, that would be on the
Okay.
January meeting.
So for Skybound, we will entertain a motion to
I will
continue.
move to continue to January 22nd.
Second.
All in favor?
Aye.
Opposed? Skybound Development is continued to January 22nd.
I also have another matter on your calendar, Starfish Drive.
Got it.
And that matter is caught up in the
Yes.
chain,
Correct.
however we're calling it, the ordinance modification. I'm hopeful, considering that it went to planning a couple days ago and was that I would request to be on the next meeting as well. I'm hopeful that we'll be able to resolve it at that meeting. I'm not sure how the timeline is going
I think
for that.
we don't have.
Mr. Serta, the reading will be in front of Town Council in February, so
Okay.
it's unlikely.
Okay.
So our March meeting is probably the most advantageous for your
Can you
application.
put me on February and stay on top of it?
We already have 5 applications in February for the same issue, so if you wouldn't mind going to March, that would be appreciated.
I'll defer to the board.
What's our date?
It's either February 19th or March 19th.
All right, I move to continue to March 19th.
Second?
All in favor?
Aye.
Opposed? Motion carries. Carrot is going to be moved, continued to the March 19th meeting. So if anybody is here about Skybound, which is Lambert Street, or Terrick, which is Starfish Drive, we are continuing both of those. Lambert is being continued to the January 22nd meeting, and Terrick is being continued to the March 19th meeting.
Good luck all, have a good evening.
Thank you. Okay, now we actually can. So the three items that we're going to be hearing tonight is Robbins, KSN LLC, and Pelosi. So, Robbins.
Thank you.
Good evening, members of the board. Attorney Dane Ardente for the record, for the applicant, Gal Robbins. This is a special use permit request pursuant to section 12.23 of the Narragansett Code for 163 Colonel John Gardner Road. We were in front of the planning board on this issue last month. Although the planning board had issued an unfavorable recommendation, I kind of wanted to explain a few things that we did in consideration of the planning board's comments at that time. I don't know, did we get the new maps? Okay. So one of the biggest things that the planning board wanted us to do, and this is the original, it looks like, yep. So this was the original map that we had submitted to the planning board, or site plan, excuse me. Let me back up just a moment. I'm sure, as the board understands, what we're trying to do is permit, to make legal 2 bedrooms in the basement, being this bedroom and this bedroom. So what the board had requested we do, the planning board, is they had issues with these being doors being considered legal bedrooms. So the planning board had asked us to remove those and come back before them. We had expressed to them respectfully we're happy to remove those, but we would rather just bring it to the zoning board in consideration of the zoning board being the ultimate authority that votes on it. So although the planning board didn't necessarily love that we didn't want to bring it back in front of them, we nevertheless took their comments to heart, took those doors out, and are willing to do so. Any questions about that specific issue before I go on? Or?
So what are you going to be using those, that bedroom for now?
Well, it's not going to be a bedroom anymore now that there's no doors. It's not a legal bedroom at this point, but it's just going to be storage space. Maybe kind of just a...
Can you point out where the doors are again?
Yep, they would have been right there and right there.
Okay.
This is the old site plan that we presented to the planning board. So in consideration of that, now, the concern that they had was that there could be a 3rd bedroom. This was going to be closed off to prevent it from being a 3rd bedroom. They had concerns with there being doors there, that it would be technically, legally still considered a 3rd bedroom. So in order to kind of quell those concerns, we were willing to remove the doors. That way, we only have the 2 bedrooms, which would be what we're here before you tonight.
And the staff's project summary did indicate that you'd be willing to do deed restrictions?
Yes.
Okay.
I'd be happy to entertain any questions. Otherwise, I don't know if there was any specific concerns that this board had.
Is that the end of what you're presenting?
Yeah, I mean, really what we're presenting is, everything else is in conformance, and I guess I could go through the standards as well. But in terms of 12.23, the site shall conform with the underlying zoning designation. It's in an R10, and this is going to be under the performance standards under 12.23, which allows more than 4 bedrooms. Permitted uses, the project must meet the definition of a single-family home. Obviously, this is a single-family home. Parking, we have to demonstrate that there's adequate parking on site. The one thing I will touch on this is that the applicant previously received a permit from the town to add 200 more feet to the existing 300 feet of paved space to accommodate the 5 bedrooms. Design-wise,
If I remember correctly, on the parking, for development standards for houses that have more than 4 bedrooms. There has to be a certain amount of space for parking, but parking also has to be where it's in and out without turnaround. Is that, do I remember that correctly?
Yeah, you're correct, that's part of the standard.
Okay, so, and it meets that standard?
I don't recollect whether or not it does or not.
This
Okay.
is tandem parking, I believe.
Yeah.
Then that,
This is tandem.
Okay.
How many parking spaces here? Can you show that picture again that you just had up for the
Sure.
parking?
6 spaces.
And 4 spaces are
Right.
tandem.
Correct.
all right. Does anybody remember this from the last time?
I think we did talk about parking. They said, the staff found that the project demonstrates adequate parking. I don't think they found an issue with the parking, but I do think they found issues with other items, Council, is that correct? And I believe you just made the statement that the planning board only had one concern. When I read the staff report, it seems to me that there are a number of concerns that have been raised.
Well, I'd be happy to address those concerns.
Please do.
That was the only concern, in our view, that we were willing to compromise on and fix, because that was really the only legal
Okay,
issues.
so we are required to look at evidence. So what evidence are you going to put in the record today to meet the legal standard that we have to use to make our decision? It can't be just your representations. What's your evidence?
Well, the evidence is the site plans that we would presented, number one. Number two is the fact that it's in conformance with all the development standards of section 12.23, and there's been no issue as of date where this does not meet the standards assigned in 12.23. It's a special use permit. It's conditionally permitted. We've met all those conditions.
Okay, so I'll go through the staff comments. They're saying we can grant a special use permit for single-family homes exceeding 4 bedrooms, and how many bedrooms do you have here?
We have 3 legal bedrooms,
Yes.
and we're asking for 2 more.
So you want to go to 5?
Yes.
So this standard comes into place. And number 2 says permitted uses that the project meets the definition of a single-family home. And the staff is saying in their comments, the project as proposed appears to not meet the requirements of standard 2. And then they raise some concerns about the fact that this, because of the bathroom and the ability to have cooking and the like, could constitute a freestanding unit and can be used as a freestanding unit. Your comments?
I think if we had referenced at the planning board that we'd be happy to take out the cooking facilities to address. Oh, excuse me. I'll let the applicant speak. This is Kelly.
Okay, thank you.
I believe at the planning board, they had.
You have to be sworn in, so if you're gonna testify, I'll need you to, right here.
Yeah. So it's not, and the applicant brings up a good point. At the planning board, they had said since you can move freely with the laundry room open and there's no close-offs there, that the kitchen is permissible and it doesn't make it a new living facility.
I thought I remember reading that the fact that it had a separate door that allowed you entrance into the basement was their concern about it being a multifamily or potentially a multifamily, which is not allowed in the R10s. So how do we get around a separate entrance that allows a...
Well, we'd be happy to close that off and make it just a single entrance down to the stairwell.
Can you address the fact that this, whatever was done down in the basement was done without permits and without any type of application or anything like that?
So there was a mixture of kind of the sellers that my client had purchased the property from, along with my client, perhaps not checking as closely as he could have checked in order to do these kind of renovations. that's why we're here before you tonight. This was originally an application to permit all 3 bedrooms. However, just based on neighbor comments and testimony, we found that to be excessive and quite frankly unfair. So we're coming before you as a retroactive permitting of the 2 bedrooms and trying to see what would satisfy the board in order to accomplish that.
So counsel, I have a question about that. Is your client going to be sworn in and answer questions? That would be my first.
I'm more than happy to put them up.
Okay, because you just made a representation. I think that your client didn't know about the permitting or something to that effect, you just said. And what I'm referencing is Mr. Pimentel in his report says that when he spoke with your client, when he first went in to review the property, to look at the property as a result of the complaint that was filed, your client said the basement was in that condition when he purchased it. And I believe that was what Mr. Pimentel said in his report. And now you're saying something different. So which is it?
Well, I mean, in terms of structural renovations, I don't know. Perhaps I can swear my client in to speak to that. But in terms of normal...
Because that goes to the chair's question to you about applications for permits, because it sounds like 2 different things are being said. If we believe what Mr. Pimentel has said, your client made a statement to him that the basement was done on the day that he purchased it. If we don't believe Mr. Pimentel, then we've got another version of what's going on here.
I think he also checked with the Realtor and verifies that it was not finished.
Right, right. So that leads me to conclude that a misrepresentation was made, and I don't want to have a continuation of that here in this hearing. So the question is, you know, why didn't he pull the permits?
My client has expressed to me that he did not make that representation.
Okay, so we have a question of fact, so we
Yes.
need to hear from both parties so we can make a credibility determination.
Well, I'd like to swear in the witness at this time, the applicant, Cal Robbins.
Please raise your right hand. Do you solemnly swear the testimony you give in the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I did.
Please state and spell your full name for the record, please.
Callan David Robbins, CALLAN DAVID
Chair?
You go
All
go
right.
right ahead.
So, sir, when you bought this property, what was the condition of the lower level?
I've maintained the whole time that some of the things when we bought the property were there, and some of them we have.
Can you
I've done
clarify what was
ourselves.
there and what wasn't?
Sure, there was, the basement was studded, it was plumbed for all the water. There was, the whole laundry room was there, the bedroom, the flex space that's right there, that was all there. There was a vanity, there was sheetrock hung, windows. Some of, the space over here, existing mechanical was there. This entrance was all there. The, like I said, the laundry room and the stairs down to the laundry room were all there.
Okay, stairs to the laundry room were there, and you say that you say the laundry room was there and the stairs going down. What was framed, and where was the plumbing you referenced?
Yeah, the plumbing, right where that existing bathroom is, that was all already plumbed into the, concrete.
So rough plumbing?
I don't know the definition of
Were
that.
there sinks and toilets or just pipes?
Just pipes.
Okay.
Yep.
Were the walls in for the bedrooms?
Yes.
The closets?
Yes.
The door-
The closets, some of them were there.
The doors?
The doors were not there.
Were the egress windows in place?
The windows were in place,
No.
but I think, I don't know the answer to that, sorry.
And what work did you do?
Myself?
Well, have done?
because not all the sheetrock was hung, we hung sheetrock, we painted, we added doors. Like you said, the toilet, the sinks.
Flooring? What's the flooring?
Yes, there was, LVP flooring put in.
You put that in, or was it wasn't there?
It was not there.
And what investigation did you make about your obligations for permitting before performing any other work in this space?
Not enough investigation, obviously, and that's why we're here. We're trying to make it right, and that's what we feel like we've done the whole time, is to say, hey, we realize there's an issue here, and we're trying to fix it.
Have you, one of the documents that we've received from a neighbor suggests that this has been used as an Airbnb, which is perfectly legal to do, so I'm not suggesting that it's not. My question to you is, was the lower level offered as a separate Airbnb at any time by you?
No.
Did you offer the entire unit as an Airbnb?
Yes.
And when you listed it, what platform did you list it in? Who handled the rental for you?
Oh, myself.
You did it directly?
Directly with Airbnb?
Did you
or
do Airbnb, VRBO?
Both.
Okay.
Both.
And when you listed it, how did you list it?
Just on Airbnb, on VRBO, we've done it just
As
through.
how many-
I think how many bedrooms?
How
and
many
bathrooms?
bedrooms?
Oh, sorry.
I think it was 5 at
5.
the time.
I believe it could be 6. Yeah.
Okay.
So I have a question, a couple of questions actually. One is, there is a kitchen unit in the lower level.
Yes.
Did you install the kitchen unit?
Some of it, yes. Some of it was there.
Okay. So the question is, if there's a kitchen unit there, I think one of the main concerns from the planning board was related to the fact that even if you reduce it to 2 bedrooms, the fact that there is a separate egress and the fact that there are sleeping, eating, cooking, and sanitation containing a separate means of egress and ingress, the staff cannot rule out the possibility that the existing dwelling could be converted into a 2-family. So you're saying you never rented it as a separate unit. Why put the kitchen unit in if you never intended to rent it as a separate unit?
Sure. I'm retiring from the Coast Guard here in 6 months, and we plan to move back to this house full time. My mother-in-law, who's here, is also planning to live with us, so we felt that, you know, having that down there would aid in, living in the same home.
Why not apply for an accessory dwelling unit then? If it's the intent to have a relative occupy that unit, why not follow the code and apply for accessory dwelling unit?
I'm going to object to this based on relevance, in the sense that he's applying before you got it. We understand that there were issues originally with the actual build-out, or whatever you want to call it, improvements, with the actual property. We're coming to you tonight because he meets the standards under the actual, the development standards under the code for 12.23. So it's not a dispute that there were issues with him maybe doing certain things without a permit that he might not have known. Doesn't matter. The point is, we're before you tonight. We took planning's comments into heart, presented you with a new plan, and we're trying to make this the best situation possible based on facts. You'll have to forgive the sweat I'm getting over.
All right, no,
My
it's warm
apologies.
in here. Are you feeling okay?
Yes.
What I'm a little bit confused about is you keep saying we're in compliance, and I'm looking at what the planning board, and they recommended that the application be denied for the following reasons. Number 1, that the project is not in compliance with the development and performance standards. 2, it's be denied because it is not compatible with surrounding land use and protection for adjoining properties from any adverse effects. Number 3, it's be denied because of capacity of public facilities, including but not limited to, etc. And then next, that it be denied because the project is not in compliance with the land use component of the plan specifically, and they talk about land use policy LU 2.2 and LU 2.5. And I'm trying to give you the opportunity to address these things, but you just keep telling us it's in compliance, so.
I understand.
If I may also, I'd like to address one particular development standard that I'd like you to address, please. So, development standards for homes exceeding 4 bedrooms, and this one's going to be 5. Parking. The project must demonstrate that the project demonstrates that adequate parking on site that meets all the applicable provisions of the zoning ordinance. In addition to the parking requirements of section 7.9, there shall be no parking improvements allowed within 2 feet of any lot line. So that refers us to section 7.9. Dwellings exceeding 4 bedrooms. A parking area equaling a minimum of 300 square feet per bedroom or occupancy shall be required in compliance with section 710. So first of all, we do have the 300 square feet per bedroom. Okay. So then it refers us to section 10. In all residential developments exceeding 4 bedrooms and all non-residential developments, each car space shall be at least 8.5 feet wide, 18 feet long, and shall be served by suitable aisles, each lane being a minimum 10-foot width or greater if required by the building official based on conditions to permit access to all car spaces and egress from the site in a forward manner. So that's, you get there a little backwards, but you get there. So is that what we have for parking spaces? Do we have all car spaces egress from the site in a forward manner?
I would defer to the building official as
Okay.
he typically would use for parking.
Yeah, I would say based upon the square footage that was indicated on the plan, plus it's almost like a circular type of driveway, that it could meet the standard of
Could.
backing
Okay.
out, going around the circular to exit in a forward motion. I mean, it would take some, with 6 cars, or 5 cars, it would take a little bit of manipulation to do that, but it was felt that
Okay,
that
so you're all,
didn't meet that.
then
Parking
building
will
official is
apply.
all set for parking. Okay.
And additionally, I'll represent too that the additional asphalt was at the applicant's request of how to bring it to conformance with the building department, and that was the building department's instruction.
Is this at all a student rental?
Currently, yes.
And how many students are there?
5.
Do we agree with that? Have we investigated that?
We haven't, we've been told that it's 5. It was originally 6 bedrooms, but we've been told that it's 5 students there.
Both leases were presented to the inspector that came back to show 5 as well.
When you say both leases, there's 2 leases?
Yes.
And that's because there's how many units? One for each unit or one for?
Originally, we got 3 people in, and then, we couldn't find someone that wanted to do 5 students. So, yep, they share the space and they're comfortable with that.
I'm sorry, did you say there were 2 leases?
Yes.
And one was for 3 bedrooms, and is that for the first floor?
Yes.
And then there's a separate lease for
Yeah,
2 bedrooms for the second floor?
Right. They share. They can move. They move freely. They share all the spaces between it. That took some work to talk to them to come to that, but yeah, they have access to the entire house. The first, like you said, the first lease that is the 3 bedrooms on the first floor, and the second lease is 2 bedrooms on the bottom floor.
And additionally, we're here before the board representing, and also will implement as well, to make that such, in the sense that that'll be an open floor space. There will be no separation of units. Because we understand that that was a genuine concern of the building department, genuine concern of butters, and a genuine concern of zoning, is that these are 2 separate units. So we wanted to represent and do as much as possible to show that these are not in fact separate units. These same unit, 5 bedrooms.
So could
3
you,
currently, 5.
could you show us a picture of the open spaces that you're talking about?
Sure. Can we go back to the new plan? So other than, you have the first floor, do you remember the one of the first floor from the last meeting?
This one?
No, the main floor.
The main.
Yeah, me. So we have the main floor, stairwell that goes down, then we can go to the newest one. And as we had represented before, we're taking out the doors that are going to close off any kind of open ingress and egress. And then essentially the same thing, open floor plan, 2 bedrooms, open, I don't want to say open space, but open storage area, right?
It's a little hard to see it with the current lighting. Is there a way to, why don't we,
Can you put your red dot on the doors that are going to be removed without moving it? Thank you. And what else? All right, and what about the door at the bottom of the stairs?
That one was supposed to be removed, I'm not quite sure why that wasn't removed off the plan, but.
That actually, sorry,
Sure.
yeah, so that is a
Upstairs.
closet right there, if I can. This is on the bottom floor, this is a closet.
Okay,
These stairs go down
With no door.
and then out of here. There's no, if you go back to the first floor, there's no door at the top of the stairs. See, this is
Okay.
the entrance to the house. You can go straight down, and then the laundry room is right here, if that makes sense.
Is there a door at the bottom of the stairs then? There it shows
To
a
enter
door.
the laundry room,
Yes,
yes.
okay.
that door will be removed?
We are happy to remove whatever doors anyone would like. So that door is really there just for heating purposes in the basement.
So you have to go through the laundry room to get to the rest of the living space?
Well, it's not gonna be a laundry room anymore.
You can go through here, and you can also, there's an entrance right here to get down. to
But that's
house.
from the outside.
That's from the outside, yes.
But from the interior, you have to enter that, what you're calling a laundry room, to get into the living space.
Correct, yeah. This entrance from the outside has always been there. And then this has always been exactly how it was, if that makes sense.
Were those window wells on the top, I'm referring to the bump outs on the top, were they present when you bought it? The bump outs on the
Those are
top?
egress windows. Those are all considered egress windows.
Those are egress windows.
Uh-huh.
Were they there or did you install those?
They,
These guys.
yeah, we added those.
so I'm having a hard time reading it. So
Mhm.
where this, you were saying it goes in, that says laundry room there right now?
Existing laundry, yes.
Okay, that is much better, thank you. So then we have a flex space, existing living room, existing mechanical bedroom, and then there's the kitchenette, existing bathroom, and bedroom, okay. And then can we go back to the first floor?
This is the first floor.
Yeah. So you walk through the front door and then that's the existing kitchen, living room, dining.
Yes.
So, is it part of our purview, is it that they don't have permission to rent all 5 bedrooms, but they currently are? Is that before the board at this point, or is that not part of the board?
Isn't that the subject of the appeals? There's a couple NOVs, notice of violations, that are not on this meeting tonight, is that right?
Yeah, there was a second notice of violation issued in which that will be enforced.
They'll be enforced?
Yeah.
Okay. And the enforcement of that involves
we'll go through municipal court to enforce
That's the other thing, right?
the use of that lower level by students, which has not been permitted.
And there are safety concerns there.
Yeah, I mean, we never did any inspections on any of the work there, electrical, plumbing, mechanical, so there's absolutely safety concerns for having students down there.
Is this zoning approval subject to that, or?
No, this is completely separate. Just to kind of give you just a little background, when we were first notified of this by complaint in November of 2024 by a neighbor, we met with Mr. Robbins. That's when he told us verbally when we did an on-site inspection that the work was done when he purchased it, I think 6 months previously to that. So based on that, we deal with this all the time.
So, wait, can I think we have to swear you in because we're actually
Sure.
asking.
Do you want me to come up and speak over
Yes,
there?
yes, please, and
Raise your right hand. You solemnly swear the testimony you give in the matter now hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please state and spell your full name for the record.
Sure, Wayne, W-A-Y-N-E, Pimentel, P-I-M-E-N-T-A-L.
Mr. Pimentel, what is your position with the town?
The building official?
Could you just go through
Sure.
the notices of violations and stuff on this property and the history of the request for the zoning relief?
Sure, absolutely. So we received a complaint in November of 2024 from the neighbors that construction was taking place at the property. We then contacted the owner, Cal Robbins, to set up an inspection to confirm whether or not what was being done there. My two inspectors, Troy Holden and Joe O'Neill, met with Mr. Robbins on November 27th of 2024. That's when he had informed us that the work had been there in place when he purchased the property. I think it may have been a year prior to that. I think it was in August of 2023 is when the house was purchased. We deal with this a lot where people buy houses, basements are finished or other rooms are finished, so we work with them to legally permit them, go through the permitting process, obtain permits, obtain the proper professionals to check that work so we can legalize it. So we had informed Mr. Robbins that the same would apply here because he had stated that it was in fact purchased that way. We told him he needed to submit a building permit application with plans, which he did. We then did a denial based on that because he was creating there were extra bedrooms in the basement beyond the 3 and over the 4, which triggered the special use permit. So he's moved forward with that application. That's the one before you tonight. I believe it was in September of this year, the house was cited by a nuisance violation for the police department. There was a party on the premises. That's when we found out that the basement was being rented. There were 5 students there. And that's when I cited him the second time after confirming that there was work being done there that was not permitted, was not represented to us correctly. I reached out to the original realtor who sold the house, and she confirmed that the only thing in the basement was a laundry room and nothing else. So the second violation will be handled separately. So, like I said, basically, because this was formally submitted, we were told by legal counsel to move forward with this application, as it is independent from this subsequent one that was issued last month.
Does anybody have any questions for Mr. Pimentel?
What was the date of the first meeting that your department had
With Mr. Robbins,
please?
November 27th, 2024.
Okay, and that's when you told him that you would work with him?
Correct.
And then subsequent to that, he entered Were the students in place when you people did that inspection?
We weren't aware of it. There were 3. We had a lease for 3 as a rental, but we weren't aware of any students living in the basement at that time.
Was it ever discussed with the property owner that it shouldn't be used until it's properly permitted?
I mean, that should have been,
That's clear?
I mean, very clear that
Okay.
without it being permitted and inspected, that should not, certainly not be used.
And that's what I'm getting to, because if you went in November of '24 and it was leased to 3 students, those students would have been out by May of 2025, and then he would have entered into a whole new lease at that point with 5 people. The 2 leases, one for 3 and one for 2, and that was months subsequent to your initial meeting with him.
Correct.
It also sounds like it was originally leased just to the 3 upstairs, and then a secondary lease to 2
No, we're
more.
talking 2 different years. The first,
But currently,
Currently,
under
exactly.
your
Yeah,
description,
in 20,
They-
in
they left.
2024.
they left and then he went ahead and leased it to 5 people.
Okay.
Yeah, when we first met with him in 2024, up until he submitted a permit to legalize it, and we sent the denial letter in March of 2025. We were under the assumption that it was just 3 students living upstairs, and he was going to go through the process to legalize the lower level.
And then subsequent to that, he put 5 students in.
There was, like I said, there was a nuisance violation in September of this year, and we always visit those. The police document, we document how many students are in there, and that's when it was determined by speaking with the students that 5 of them were living there.
and you don't enforce the removal of the 2 students that technically are not living there legally.
I would have to do that through the court.
Yeah, but I think the point, what I'm trying to get at is you had given him indication that these things needed to be done, and then with knowledge of those facts, he went ahead and had it entered into a new rental to 5 students. And that's after his conversations with you, after you told him what would be required.
That's correct, yeah.
Thank
I mean, we weren't aware that he was going to try to, well, we weren't aware that the other bedrooms in the basement were going to be rented while we were going through this process to try to legalize it.
Okay.
Does anybody have any questions? Do you have any questions for?
I don't have any questions for Mr. Pimentel. I just want to redirect the board's attention to the fact that this is a special use permit.
Thank
This
you.
is, I mean, I understand that the board has to do its fact-finding mission, but they're finding the wrong facts. This has to be catered to the actual development conditions, or excuse me, development and performance standards of a special use permit. That's it. That's the only thing that this board has the power to do right now. My client's been very forthcoming with the building department, the planning board, planning department, and this board about what happened. I don't see how it's, well, I know it's not relevant, but in terms of the special use permit, but I would like the board to consider the actual special use permit conditions, right?
One of which, though, is that it cannot be used as a multifamily property.
Which it's not being used as multifamily property, and we're here presenting you the plan showing you exactly what we're doing to not make it multifamily.
I'm not quite sure I'm as clear in my own mind about that, given the fact that there's 2 sets of leases here, and the building department has told us that this can be rented as an independent unit.
Well, if we're taking out the doors and we're not renting it as an independent unit, if they have free reign of the whole house, which they do, as my client has testified, it's not a multifamily. May it at one point, could it have been considered a multifamily?
The external-
Possibly.
The external egress is a big factor.
All
in
right,
that.
counsel, will you address how the granting of the special use permit will substantially serve the public convenience and welfare? That standard, as you're pointing out to us, the standards, that would be under special use permits number 5.
Is that section 12?
12.5.
12.5.
Yes, so those are the general special use permit standards for the
Yes.
town, correct?
Yes.
Okay. Recently, I don't know if this board is aware, that state law has changed to where special use permits are required to have specific and objective criteria attached to each and individual special use permit, okay? If the special use permit does not have specific and objective criteria attached to it, that special use is a permitted right. And I can read you the statute, I'd be more than happy to. Those standards cannot be applied against the special use permit. Now, the performance and development standards in section 12.23, although I think they're performance standards, I'm willing to concede with this board that they're probably special use permit standards. So in this case, 12.23 is the only thing that applies. You absolutely cannot apply those general special use permit standards to the special use permit.
Well, okay, I appreciate your argument. This is what we have to work with. We
It's-
have to
It's
work with-
against state law that just changed.
We have to work with what we have in front of us, otherwise we would be engaging in what people pejoratively call judicial activism. We would be,
I would beg you to consult your legal
With-
counsel on what I just went through.
We're just gonna do that.
okay, we're gonna do that.
Are we still in the same position, are we in the similar position we are to the, the tear downs where our ordinance says one thing, state law may say another? Do you have an opinion on that?
Attorney Ardenti accurately reflects the change in the General Assembly's approach to this, where they, I'll use a anecdotal word, tightened up the requirements for fact-finding, as opposed to those types of standards set forth in 12.5, which are embodied in your own ordinance. Those were in state law, and they're vague, and the courts have continued to say that the vagueness in the fact-finding process often doesn't lead to equitable results. So 12.23 is a representation of what the new law is now. I would, however, point out to you, though, that section 2 of 12.23 is pretty clear on the definition of a single-family house and does not require any additional special use permits. There are all kinds of fact findings that can be made here based on the testimony that's before you as to whether it meets that standard of a single-family house.
So you're saying we need to look exclusively at 12.23
Correct.
and make our findings as to the 6 paragraphs in that particular section?
Correct.
Okay. 5? 5, excuse me, 5.
And I think staff review has determined that number 2 is the one that does not comply.
What is that?
I think the staff review has determined that number 2.
2 does not,
Right, okay.
And the interesting thing about this, so I can clear, my father's still in my head telling me not to talk like a lawyer, even though he hasn't been gone for 20 years. The standards set forth in 12.5, I said are subservient to the standards set forth in 12.23 specifically because the General Assembly passed it. But as to the application of the rest of it, this particular 12.23 is a development standard for homes exceeding 4 bedrooms only. So this is what the General Assembly and the court would say are the rules of the road when you're assessing the granting of a special use permit or relief for a home that exceeds 4 bedrooms.
So we've established that the parking is valid. The site plan, underlying site plan appears to be, we have the complete, I think we do. It is a legal, non-conforming buildable lot. It's already been built.
Correct.
Doesn't require any special dimensional variances, because it's already been built. And it's not a incorporated into the design structure. Does the second floor or the main level exceed 40% of the gross floor area of the entire structure?
Well, could I interject? That would be on lots of less than 5,000.
Okay.
Less than 5,000 square feet, this would be above.
Correct.
Sorry.
It's not a three-story.
So, just one more time on why we just have to worry about development standards of 12.23 and not the general development standards of 12.5. You would think we would have to worry about 12.5 as well. What is the rationale for that, for special use permits?
Well, the rationale is the General Assembly passed a bill and it was signed by the governor where under these specific circumstances, these are the standards to be met. There are other aspects of the general standards, I would say, are more general in nature. And the reason for the existence of this new ordinance and the legislative enactment by the General Assembly is because there were several court decisions criticizing that the findings of fact in something that is not specific as to what it is that should be found in this particular situation, the 4 bedrooms exceeding, lent themselves to the General Assembly saying, you don't consider 12.5, you consider 12.23 as the rules that you would be guided by in making your decision tonight in this application, or one that's under the exact same subject matter.
So I have a question for you.
Sure.
So if we look at 1223, it says, we quote, may, quote unquote, if the work complies with the following standards. How does that work, that word may, not shall, how do we apply that?
Well,
If we can't look at anything else.
It means that it's not mandatory that you grant it, the word may. And there's nothing beyond it to be reached out to by the use of the word may. It is not demanded by the law that you, as soon as you find these facts, that you do it. You could say, for example, there was some inquiry about the path of this application for the last 13 months, and the cooperation, and whether or not that what you see on the map is, or the plans, is consistent with something that you can rely upon. So in that instance, you could find as fact that some of what you've heard, because you're fact finders. Fact finders also find truthfulness.
So exactly. So if I understand you, what you're saying is you can meet to the letter 1, 2, 3, 4, 5. We can't look at this other vague language that we previously looked at, but we could still use other facts to make our decision, and we still have some discretion so long as there's some rational, factual basis for the denial.
It's not mandatory, and if you were going to exercise the maybe or the may, you would make a finding of fact.
Mm-hmm.
I'd say, I don't wish to grant this based on these factors, or this fact, one fact in particular.
So the kitchenette in the basement, the fact that there's separate egress, and it could be used as a two-family, even though it is not the intent, it could be used. That's a fact.
Yes.
And/or the whole process by which the whole matter came before us. And if we find there were misrepresentations in the course of the application, anything we can't look at?
Well, I'd be trying to
all right.
figure. I would say that you, everything you said is right on, spot on. Those are things to consider. And any witness testifying under oath is subject to the usual assessment of character, truthfulness, etc.
Okay. I don't.
Is there anyone here who would like to speak either, let's do in favor of the project first.
We have a letter that was submitted by a neighbor in the neighborhood. I don't know if you can read that in the record.
We weren't able to get it in time for the meeting. No, I wasn't able to get it in time for the
Yeah, I don't recall receiving a letter.
meeting. It was just sent, like, right before the meeting. No, we didn't get it. Literally just before this meeting.
It's hearsay, but I'm not sure
Stop.
You're looking for the letter, is that right?
No, I'm looking for the definition currently. I forgot my binder. In a single-family home in Narragansett. I don't know if you have a copy of the code, Ryan.
We've got it up here. You're welcome to come up and look.
I'm flicking through it on my phone. I don't want to take pictures.
Is there anyone here who wishes to speak against the project? Sir, would you come forward to be sworn in, please?
Please raise your right hand. Do you solemnly swear the testimony you give in the matter now will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state and spell your full name for the record, please.
Donald B. Coletti, D-O-N-A-L-D, B-C-O-L-E-T-T-I.
Hold on one moment, Mr. Coletti. Are we all set? You good? Okay, go ahead. Mr. Coletti, you're all set.
I might jump around a little bit. Anyway, good evening, Mr. Chairman and the entire committee. My name is Don Coletti. I have owned a home directly across the street from 163 Colonel John Gardner Road for 42 years. Also, I'd like to tell you, I've been a realtor in the state of Rhode Island for over 52 years, and I've testified before many city and town zoning boards as a real estate expert regarding all and any zoning matters. This petition, by those who have signed and own property within the 200-foot radius of the subject property, reflects that the signatories are against the applicants obtaining approval from this zoning board due to the changes in the approval of a 3-bedroom single-family home to a 5-6-bedroom home, because there are 3 bedrooms there now. They're looking to alter it down to a 5. Right now it is.
Sir, can you stop for a second? Did you reference a petition? Did you just say petition?
Signed by
People within the radius.
Do
I
we
gave
have
it to
that?
the
Do we have
planning
that?
board. I have one for you.
Well,
oh, so you have not submitted it to the zoning?
No, it was
to
submitted
Not the
at
zoning,
the planning board,
submitted
which
to
wouldn't
planning.
necessarily come to you.
Okay.
in your
Okay,
zoning
so
packet.
would you like to submit that as an exhibit?
Yeah, you want it now?
Please, yes.
all right. So what is this exhibit 1A? How do we mark them?
Yeah,
1A?
you want me to mark them?
Yeah, have them marked.
this is one copy?
That's, yes. Because there were different people that had it signed. If I can back off a little bit.
Go ahead.
The applicant is trying to obtain approval from the zoning board to change the status of an approved 3-bedroom, single-family home to a 5-6 bedroom home, because there are 3 bedrooms that they put in the basement right now, and they're looking to offer it to a 5. So it's 5-6 bedrooms, and at the present time, it is being used as a 2-family income property that already contains additions and/or build-outs, which have been done by the current owners only after their purchase of this property, which happened on August 21, 2023. I'm going to read a letter from the listing agent that represented the seller.
I'm going to object to that. If we're not allowed to introduce evidence and support from people who are not here under...
I have an email attached to it from her. It's her email.
So we didn't actually say you couldn't introduce the letter.
I just
We
don't
just
have
don't-
it.
just
I
don't
didn't
have it.
have it
Can
before
I
I
read
walked
the-
into
can I-
this room.
Are we permitted to read the letter into the record? After, of course.
And sir, before you
I'll see
speak,
if I can print it.
what you've given us is a list of names, but it doesn't say any, it doesn't have
It says
anything.
right here, this is what they
Right, we
approved.
need that too.
I didn't give you that?
That's a, no.
No, hang on.
Okay.
So can I read the letter?
Yes, let's just try and figure, if we could just ask, if I could ask a couple questions on this. This is a copy of your testimony,
That's
it
correct.
looks like. And then these are signatures of, but it doesn't say on these signatures what
What the position is.
their position is.
It's in the letter. They read the letter before they signed.
But
They read the
if the
petition
board-
before they signed.
Are you saying your petition is, your testimony is the petition and they're signing on
That's
it?
correct. Reason it had to be done separate, different people had to meet with people at home.
I mean, I'm going to object to that just on the fact that this is hearsay. These people aren't here.
I
They
get it.
can't confirm what they
No,
testified.
look at the last page, please.
I'm gonna
Of
look,
every,
I'm gonna look.
every signature, you're gonna see somebody signed, certified at those signatures.
Mr. Craven, I'm not exactly sure what to do with this because I can't connect, it doesn't appear that we can connect this testimony with the signatures on here. I mean, I would assume that am I within the 200 radius?
If I can speak while you're looking, it sounds like you got a list of signatures.
I have a
And
list
then you've
of
got a
signatures.
separate document that says, we all read this.
It doesn't even say that.
It
It
doesn't
says
say that,
signatories on it.
but it doesn't name who the signatories are.
Mr. Clay, would you come
Yeah.
here and show me what part of this that you're saying talks about signatories? I'm not trying to be
No, I hear
obstructionist
you.
here. I'm not trying to be obstructionist, but you're saying that this petition, reflects that the signatories are against the applicants. there's no language on this petition that says we, the undersigned, are
Okay.
against.
Then you need to deal with your attorney. Let me finish my speech.
All right, this
No,
is,
you can keep that.
this,
It's been referred to, so you could mark it as an exhibit not to be considered unless
This,
it's ruled
the
upon.
signature.
Yes, that's
Okay.
correct.
All right, I'm gonna, just to be
Okay.
clear, I'm gonna mark the signature package as
ID
A.
only. For identification only.
ID only. A, and I'm gonna do the other thing as ID, as IDB.
Okay, please continue.
Continue.
Yes.
I have a letter in front of me from the listing agent who represented the seller that sold the property on August 21, 2023. This is from Sharon Remington Ford. I am writing this letter concerning the sale of the property located at 163 Colonel John Gardner Road. My purpose is to provide information regarding this real estate sale. The property closed on August 21, 2023, and I was a listing agent. When the property was transferred on 2023, the lower level consisted of a finished laundry room, a small unheated storage room with no closet. It had paneling and it had a raised wood floor. And the remainder of the lower level completely unfinished. Only area in the lower level with heat was the laundry room, so the water from the washing machine did not freeze. In closing, at this time, the property was transferred on August 21, 2023. The lower level featured a completed laundry room, heated. The remainder of the lower levels, apart from the finished laundry room, was unfinished and unheated at the time of the property's transfer. The unfinished space housed the heating system and provided additional storage area for the property. Sincerely, Sharon Remington Ford, and her email from her testifies that's what she did. And I also
Would you
think
like
the
to
building
introduce that?
inspector's office talked to her directly too.
Mr. Colletti, would you like to introduce that as an exhibit?
Okay.
You can object to that one as hearsay as well.
I'll call that number 3.
Yes, please.
Okay. Everything that has been done was done on the sneak by the present owners of this property, way before asking and obtaining the town's formal zoning approval or rejection of the 3 bedrooms, and it is not a small operational kitchen or a kitchenette, it is a full blown out kitchen. It's not a kitchenette. Kitchenette can go into a house. So it's a full kitchen, a full bathroom was put in, a lot of electrical wiring was done, additional heating, there was no heating other than the laundry room. Windows were put in, and much more in the basement than we know of. And all with no building inspectors' inspections. Everything is behind whatever the wall is, wiring's probably no good. I find this zoning request to be one of the worst requests that I've ever heard in all my years, mainly due to the fact that the owners of 163 Colonel John Gardner Road took matters in their own hands by totally ignoring Narragansett's zoning procedures and requirements. Needless to say, they have no concern for any of their neighbors. By altering the house and then asking for relief or forgiveness of the violations for doing what they did, I don't think so. I believe that the building department, zoning board, town attorneys need to handle this situation and these owners just as was done with 50 Anchorage Road. That was at the time the fairly completed new 3-story house that was almost complete and almost finished, when the owners were told that it had to be reduced in size to meet the zoning requirements. And that was done. Those people actually took it right to the ground, 3 stories. When this property was purchased by its current owners, the basement was completely unfinished, except for having 2 cabinets on a wall for storage in the middle of nowhere, and a room 10 by 10 with a wood floor and paneling to store the original owners, the people who built this house in 1983, their deck furniture. They used to bring it down for the winter, never renting the house out. When this home was being marketed by the realtor who was selling the property in 2023, it contained pictures of every room in that house. The only room in the basement was the laundry room. You can look on the site and go from there. And in her marketing program, she states there was only 168 square feet of finished space in the basement. That is the laundry room and that 1 storage room. And the same 168 is actually on the current building department's field card. If you open up the field card, it'll tell you there was only 168 square feet that was finished in that basement. Also, no property owner within the 200-foot radius were ever given a notice of the proposed changes that were done. I don't mean this meeting, okay? Because they never wanted to apply for one. They intentionally tried to sneak the changes by the world. When this house was originally built in 1983, it was built with a non-compliance approval by the town due to the fact that the lot was undersized to build on, containing only 6,839 square feet. This is what the zoning was back in '83, and the same zoning is there now. 10,000 square feet minimum lot with an R10 zoning is required. Also, the original building permit stipulated that the number of off-street parking spots was limited to 4. These same owners this year put in an additional asphalt parking area or parking lot to accommodate 6 to 10 cars, when they now can hold probably 12 to 14 vehicles. You can wrap them around the entire area, where the original permit allowed only 4. This same asphalt area that they put in has created a runoff every time it rains onto the 2 abutting property and the 3 to 4 houses directly across the street, which CRMC, I can tell you, they're not happy with it now, okay? Due to the fact, with the closeness to the cliff, and number 156 Colonel John Gardner Road, which is across the street from the subject property. When they built the house, CRMC made it mandatory. They had to put in a holding pond. These people just put in asphalt driveway, so we got a total runoff. We are asking that the new parking area that was installed this summer with no permission be totally removed and the sod be put back as it originally was. We are
Mr.
requesting that the building department enforce and
if I just could clarify something. I mean, that parking, the changes to the parking and the asphalt and everything, that's all approved. That was approved by the town. So, I mean, asking
I
to
don't
have
think
that
so.
removed.
You call CRMC up. You're gonna scratch their
Has
head after you talk
CRMC
to
issued
them.
any notices of
These people are
violation
gonna-
for them?
They're gonna scratch their head.
Okay, but
Well,
was it the
the
case that?
driveway was approved as part of the initial application to make this legal.
Okay, but then they did some expansion of it, right?
Well, then we found out that, you know, the work was done,
Oh, I'm so sorry.
the work was done by the owner, it wasn't purchased that way.
Okay, so there was
Right.
some additional work done to the driveway that
A foot, no,
was not
a separate
permitted. Hold
foot.
on, Mr. Clay, hold on, I just want to ask.
That was to try to make it legal, when we allowed him to go through the avenue of making it legal, when he represented to us that it was purchased that way. So we said, this is what you have to do, you have to get a special use permit. You have to get, your driveway has to be expanded to accommodate the 5 bedrooms. So that's when he proceeded to do that. I believe he got a street opening permit from the DPW to do that extra opening into the street. So that was done under the assumption at the time that we were trying to help them legalize it, not knowing that it had previously been constructed by the owner. If that
Got
makes
it,
sense.
so the parking stuff was done assuming that it was gonna
Yes,
be legalized.
that would have been
but
part
then-
of the
okay.
requirements to legalize it.
Ms. Carnot, to Wayne's point, I also can confirm that DPW did issue a permit from the town's point of view. However, CRMC has not, they have not received an assent and they are within 200 feet. And if this were to receive approval, I would recommend an additional condition that it would be contingent upon CRMC approval would be added.
Right. So, okay, so CRMC did not receive
No assent has been issued.
no
for-
assent,
Yes.
okay,
Excuse me, know what?
Assent.
assent,
An assent.
Approval.
approval.
Yeah, a CRMC assent has not been
Correct.
approved.
Okay, so thank you,
They put on the additional asphalt driveway with a separate drive out. They did not make the original driveway bigger. It's an attachment. It runs right out to the street. When it rains there, it's all downhill, and it goes and hit the cliff, goes into the holding pond, and honestly, goes into my basement. So we're asking that that be removed. This home, since owned by the current owners, has had on a weekly basis 12 to 15 unrelated people in the house, on the first floor and the basement. Just 6 to 9 weeks ago, because we were supposed to come before this board 3 or 4 weeks ago, so I got a week.
Mr. Cleddy, so you, how do you know that they're unrelated?
How do we know? The police showed up. They
Okay,
talked to the 3 girls on the first floor, and the 3 girls said, we have 2 separate leases, we're on the first, 3 of us, there are 2 people downstairs, we have separate leases. That is in the police report.
we understand about the separate leases.
Okay.
I just wanna sort of kind of keep it
Oh.
to the facts, like,
The noise was outrageous, the police were there, so that's what happened. And this all happened, by the way, 1:30 in the morning, not in the afternoon. All right, as we speak, I think everybody's aware, this is currently being used as an illegal 2-family. Bonnet Shores is pretty much a single-family development, okay? These people had no thoughts, no conditions coming before this board to get it legalized. I know the inspector was up there, but my report reads, the building inspector did an inspection on November 27, 24, and found the entire lower level was built out in 5 or 6 rooms, or was told that it was, with new wiring, heat, windows, and stated to be corrected, or there would be a fine, a violation per day for every violation. That hasn't been done. On September 18, 25, the Building and Zoning Department wrote these owners that they found the same violations after the department made a visual inspection of the interior of the property, and that all violations were needed to be corrected within 10 days and stated that the same fine of $500 per violation could be charged per day, and also stated that some of them were the same 3 bedrooms, the full kitchen, not the kitchenette, the full bathroom, electrical work, the new windows, the heater was put in and installed and built out with no zoning approval. I'd like to say this, that basement, the only pipe that was in the basement was a future sewer pipe to tie into the sewers. No water pipes were in there, okay? I was there when they built the house 42 years ago, all right? And Sharon will tell you the same thing, Sharon Ford. So by putting in a bathroom, they're only putting the water pipes from the wall out, not through the concrete basement. If this board gives this application its blessing, it will show to all Bonnet Shores and all other town residents that you have no concern for our town structure. Please, reject this as you see it, and what the owners of 163 Colonel John Carter Road are really looking to obtain for themselves, and have no respect for our town and or our neighbors. So thank you for your time.
Thank you.
Questions? Am I good?
Have any questions? Mr. Fleury? Okay, thank you. Anybody else wish to speak up against the project?
Please raise your right hand. You solemnly swear the testimony you give in the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Please state and spell your full name for the record, please.
Donald P. Coletti, D-O-N-A-L-D, P, C-O-L-T-T-T-I.
Go right ahead.
Good evening, Mr. Chairman and members of the board. My name is Donald Coletti, and I'm the neighbor next door to Town and Jacqueline Roberts. The Roberts purchased the property in the summer of '23. The previous owner had a lease for the 3-bedroom house to 3 college students that the Roberts had to honor. In the spring of '24, from March until May, the Roberts had contractors working on the property. Starting in June, the Roberts rented the property as a 6-bedroom, 12-person home, which has been advertised on VRBO for the past 2 years as well. I went from the old owner renting the 3-bedroom home in the summertime to 6 people, and the 3-bedroom home in the wintertime to 3 college students, to a home that has 12-plus people living in it, 4 to 8 cars plus parked on it, and now 5-plus college students living in a multi-family home. I can stand here and talk about all the noise that comes with having a large crowd of people living at a property on vacation, but I don't want to take up the time. Finally, I have pictures available if anybody would like some. There were several things also talked about tonight that I think we had some questions on. And you may have answered it with the driveway. I do have pictures of the new driveway and the circle driveway if somebody wants to see it tonight. And also, you asked Mr. Robbins if he knew anything about the windows. And from what I saw, it seemed like he was stunned and he had to talk to his wife. So his wife confirmed we put windows in. After the contractors got done, and Cal was doing work at the house, the contractors left all the dirt behind for the 3 windows that they put in the basement after they cut through the foundation. Cal single-handedly moved all the dirt by hand in one day with a wheelbarrow in between him and his neighbor's property and just left it there. So I think he was fully aware that there were new windows put in. I want to say thank you for listening to me, and happy holidays to everyone. Thank you.
Mr. Coletti,
Yes.
do you have the photos?
Yes.
To offer with you, hard copy or?
I can text them, I can get something available for you.
I don't think we can take them that way. Okay.
I'll
Thank
make
you.
arrangements for the future.
Thank you.
But if you visually wanted to see something, I could answer
Thank
the question for you.
Thank you.
You're welcome.
Please raise your right hand. You solemnly swear the testimony you give in the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state and spell your full name for the record.
Nicholas Beltry,
Spell it, please.
V-E-L-T-R-I.
Thank you.
I am 159 Colonel John Gardner Road. I've been there for over 30 years with my wife. And basically, I was not aware of this situation until about 3 weeks ago when I signed the petition that Mr. Coletti brought up to me. So I'm kind of, new at this. The information that I received tonight, so basically my opinion is that I concur with what Mr. Coletti said. I'm not sure that 4 bedrooms is allowed, so this is 5 bedrooms, and also the floor area ratio. I'm not sure if that's been taken into consideration in this case. Front yard coverage, soft scape, hardscape, all this calculations. They're not shown, so I'm not sure what exactly has been presented.
Are you asking? Are you asking us?
Well, I mean, it's not going to, I'm just basically against the way it's proposed.
I think the only thing that is at issue here is the special use permit. I think everything else is in compliance. So none of those other things you mentioned are at issue here.
Okay. But basically, that's my take on this. Thank you.
Please raise your right hand. Do you solemnly swear the testimony given in the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state and spell your full name for the record.
Catherine Celeberto, C-A-T-H-E-R-I-N-E, last name is Celeberto, C-E-L-E-B-E-R-T-O. I live at 48 Earls Court. My husband and I built 3 single-family houses in this town. Each time we bought a lot. And when we bought the lot, it was always contingent upon getting a building permit. This was out of an abundance of caution. We know nothing about building houses, never had built houses. And I find it unbelievable that this couple would buy $1 million house and not do a whole heck of a lot of research before buying it. They also own another house in Bonnet Shores, so they do have experience buying and buying houses in this town. My husband and I are both retired, but my husband is a 36-year veteran of the Providence Fire Department. He retired as a deputy assistant chief. I mention this because he's mentioned life safety a number of times to me. And we've had a number of fire deaths in this town, a number that you don't even want me to say. But we had 2 students dying in a fire in Bonnet Shores and 1 in a fire off Ocean Road. Not reporting the number of people living in a house is a life safety issue. It's imperative that when police or fire respond to an emergency, they know how many people are residing in a dwelling. And it appears the owners did not report the real number living in this house. That said, I object to legalizing of 3 extra bedrooms or 2 or however many number it is. I don't expect the zoning board to circumvent our ordinances by issuing special use permits after the fact. There is no such term as legalize in our code of ordinances, and no law allows legalization of illegal acts. What the owner wants is for the zoning board to dismiss the violations, essentially dismiss the case against him. As a taxpayer, I've had it, frankly, with adding bedrooms and bathrooms illegally and not paying taxes on those additional bedrooms and baths. We're at the point in this town where dishonesty has become the accepted course, and we're asked permission later. This is a little joking town. Is a normal course of action. This will probably go over the heads of some people, but you and others are sending the message to the young people in this town that illegal acts and circumventing the system of checks and balances, ordinances and laws in place is an acceptable practice. Well, you're on the zoning board, you know how many times this type of action is coming for you. I want the zoning board, in this case, is to order the owners to decommission the extra bedrooms, the illegally added bedrooms, to agree to an amendment to their deed stating they will not use, however, extra bedrooms they added, to pay a fine for the time those rooms were illegally used as bedrooms, and to pay back taxes for the difference between the assessment. They're being assessed on a 3-bedroom, they have a 5-bedroom. I pay taxes based on a real assessment of our property. These people are not paying taxes on a 5-bedroom house. And they need to. And it needs to be, the amount needs to be applied retroactively. And so I want them to pay the back taxes, and I want them to back to the time when they file an amendment to their deed, that they'll only be using this house for 3 bedrooms. I just don't think we should legalize, because I don't believe there's any such term, illegally added bedrooms. Thank you.
I think I might want to just respond quickly to the zoning board's legal ability to impose back taxes. We just don't have that, we just do
I know
not have that
but I
power,
mean,
so
it'll be
I
in the record,
don't know
and I
what.
expect that somebody take some action
Okay.
this time.
Okay. Can I,
I'm gonna object.
yeah.
He's already testified.
You've already testified, I'm sorry.
That's a legal question.
Yes.
It appears we have 2 separate subjects. We have the violation, and then we have the plans that have been submitted to get approval for 2 extra bedrooms.
I stop you there.
Okay.
The violations jurisdiction is in the Narragansett Municipal Court.
So we have no say on that at all. So that's
There's a
That's
judge that's
removed.
probably in there right now doing some housing violation issues as we speak. And the building official, when this matter comes before the municipal court, will testify and dole out any punishment or any forgiveness that may be necessary. So,
And is there any ordinance that the zoning board is not allowed to hear a case that's after the fact, such as this?
there's no ordinance that prohibits that, no.
Okay. So when I read through this, 12.23, it specifies that it can't be a 2-family house.
Correct.
And for all intents and purposes, that is a 2-family house. It's got a kitchen, it's got the bathrooms, and it's got the bedrooms, separate doors. So I don't know how we get by that issue.
I think procedurally, are we done with public comment, or?
I think so. Is that the end of public comment?
If anybody else wants to
Well,
speak.
Mr. Secretary, sorry to interrupt. If people are going to speak, I would ask that they please go to the podium so that they're on the cameras.
Yep.
This is a public hearing.
Which one?
I didn't know if we wanted to incorporate the letter of, that Mr. Robinson presented in support thereof.
Take that.
Mark it for identification.
No, that's a full exhibit, I
That's a
think.
full
He's
exhibit?
asking it to be a full exhibit.
He's asking it to be placed for the,
All right, so
for the
I'm going to
petition.
make that 1, exhibit 1.
And I can either read it or,
Is that similar to the Realtors exhibit? It's
Yes.
an email?
yes,
Thank you.
I'll just read it for you now.
Did you want to read it into the record, or do you just want us to read it? We all have copies.
Yeah, if we could read it into the record, that would be much more beneficial.
Would you like a
Did you want me to
copy
do
so
that?
Sure,
people can read?
if you have a copy. Email never works with you. This is from Colonel Brendan Doherty. I'm sorry to hear, well, this was addressed directly to Callan and Jacqueline. I'm sorry to hear that the frustrating series of events. I have lived here at 145 Colonel John Gardner for several years, and as you know, I'm only 3 houses away and situated on the same side as you both. My wife Michelle and I are here throughout the year, with the exception of parts of January, February, March, when we vacation at our Florida home. We walk around Bonnet Shores and right by your house often. I drive by your house almost daily, and I'm often working in my front yard within earshot of your house. I can tell you with a great amount of certainty that I've never seen people in your yard or driveway, nor have I heard partying or laughter. In addition to those observations, I have never seen a single car parked in front of the house. Frankly, there is nothing that Michelle and I have heard or seen from your house that is offensive to the neighborhood. Address Colonel Brandon P. Doherty. Now, I think we can close public comment. If there's nothing left, I can address the questions of the board on that.
Can I ask a question?
Sure.
This sounds like a personal email, not one that's supposed to go to the board because it's not addressed to the board.
Well, I think that he's offering it as a comment on the subject matter that the board's hearing. So it would appear from my reading of it that Colonel Doherty is talking about the same house, and those comments relate to at least some of the issues that were brought before you today. And we allowed the other group to do the same thing. So if we're not going to observe the rules of hearsay, Rule 804, then and it's fine for the purposes of your consideration. And I'll say this: if I'm giving you instructions on considering it, you give it the weight you choose to.
Thank you.
You-
Thank you.
Yes, so, do I need a motion for that? Motion to close public comment?
Yes.
People? Yes. Any more wishing to speak in favor of or against this project? I mean, this matter? Okay, thank you.
Move to close public comment.
I'll second.
All in favor?
Aye.
I'm sorry, what was your question again before we?
My question was, when I read through this, the glaring thing that the planning board mentioned was and the staff has mentioned, was the two-family aspect. I see that the house plans, the first level, basement level, has bedrooms, bath, kitchen, and separate doors. So that could be construed as a two-family house.
Could be construed as a two-family house. The problem is that Narragansett's code, and the building official can confirm, neither defines what a two-family or single-family is. Okay, so we're going to have to take that on a factual basis. This is not a two-family, and your planning board has opined that as well. One of the abutters had confirmed that the entire neighborhood was built as single families. Mr. Robbins and his wife use it as a single family and don't rent out the bottom unit when they're there. This has no indicia whatsoever of a two-family. And if we're gonna call it a two-family, we have to be able to define two-family.
I'm sorry, I think I disagree, because it has a separate entrance, it's had its bedrooms, has its bathroom, it has a kitchen. It can be a two-family house.
Well,
Separate people in the first, different people in the basement.
I would posit to Mr. Pimentel what
Yeah, if I
two-family
can
classified as.
add some language that you had asked me what a single-family dwelling was. We don't have a definition, we have a definition of dwelling, but there is a definition of duplex. And if you want, I can read that.
Yes, please.
It's two single-family dwelling units, each with separate entrances contained within one building, sharing the same roof and foundation, divided by a common party wall, which common party wall must separate rooms used for human occupancy and not garages, storage areas, or areas such as porches, patios, or decks.
So that fits the definition of what he just read.
Well, but not if we have an open layout to the bottom. This isn't closed off. The applicant has testified to that.
I mean, there's nothing that stops the applicant from just closing that door and having two separate floors.
That's every house.
But not every house has.
Not every house has a
separate
kitchen
living.
in their basement.
I understand, but I mean, we would be happy to, I disagree respectfully, but we'd be happy to take that door off. I mean, if that's the only thing separating it. And you guys are gonna have serious issues if we're gonna if we're gonna consider this not a single-family home. I mean, there's plenty of evidence on the record that shows that this is a single-family home. And not to mention that the town doesn't have a single-family home definition.
No, but it has a duplex definition, which it appears to meet the duplex definition. And it has separate people living on each level. Separate leases.
So there's a lot of facts that kind of go against what you're saying. I mean, and the separate egress and ingress is an issue.
Yeah. And the applicant has and I understand the board's position, but the applicant has offered to the planning board and the zoning board to take out the kitchen, take out any common walls. I disagree. I think that the fact that having the open layout in terms of going down to the bottom floor is a single family home, right? It's not being rented as a.
I think if the kitchen was not there, and if the applicant then wanted to have an in-law apartment, come back and then sit in front of the board again to now say how they're gonna have a kitchen for a in-law, that would be the separate steps to take, I think. I'm just having a problem with the kitchen, I really am. I mean, if I read through the 12.23, the definition of a family, of being a single family, which this seems to meet, in my mind, definition of a duplex.
And additionally, too, the building official had stated at the planning board hearing that a single family can have a kitchen on the bottom floor.
Kitchenette.
What was the last part?
Public comment?
Oh.
No. Can I ask a question here? So, with the ADU ordinances, let's assume that this was a clean slate and they came in and they asked for a building permit for an ADU. And they hadn't built anything yet, and is that as of right for this type of, for what this is?
Yes, it would be limited to 60% of the square footage of the first floor, and it would be limited to not being rented for less than 12 months.
Okay.
And what would the 60% be approximately? And what's the
Would that
existing?
be?
Whatever the square footage of the first floor is,
Okay, do we have that?
it's either, because this is a two-bedroom, it'd be either 60% or 1,200 square feet, whichever's less. Seeing that this is almost
The upstairs
mirrored.
is a two-bedroom, the upstairs is a two-bedroom?
Yeah, it's three.
Three, okay.
First level.
But looking at it, it kind of mirrors, the basement mirrors the first floor, so
Okay.
it wouldn't meet the criteria. It would have to be reduced in size.
So they'd have to reduce it in size.
Yeah.
And by that, it wouldn't even, storage wouldn't even be able to be there. Is that right? Or,
It doesn't really address that. I mean, we typically include storage closets as part of the square footage,
okay.
so.
Can I ask you a question about the ADU? Do you have to be owner occupied to be able to rent it? So it can be two separate units with the owner not living there?
I think that's unclear.
Is
Yeah,
it
there-
ADU for family? It's a family member.
Yeah.
I'm trying to, I want to just, at least
Because we're not
pay
talking about.
homage to,
Depends on the lot size.
hold on, one person at a
Yeah.
time.
Depends on the lot.
One member at a time,
One person
please.
at a time. I just want to, I mean, right now, you've got college students, you've got too many college, more than what we have here, but, at some point, they did testify that they wanted to bring, I think, your mother-in-law in, so.
I don't have all the criteria in front of me for the ADU, so I don't want to misspeak, but
Right.
if that's something they wanted to pursue, I could certainly run them through what the requirements are for that and the different scenarios, because there's quite a few different scenarios that permit ADUs.
Okay. Did you want to just conclude, is that where we are at that point?
Well, I mean, that's the evidence that we placed on the record. The board is limited to the development standards of 1223 on it. So, I mean, I don't know what else to say other than the fact that it's clearly a single family. If there was any questions as to whether it wasn't, these plans themselves would certainly make it a single family. Or quell any of those issues. The other thing I did want to say too is if the board were to approve this, there was mention of making a special condition that CRMC assent be obtained. That goes contrary to the actual zoning ordinance, which requires that in 1223 3, project demonstrates adequate parking on-site that meets all applicable provisions of the zoning ordinance. So any kind of CRMC assent, whether it's needed or not, is past this board's jurisdiction.
But I thought because it was 200 feet that it's required.
But that is not jurisdictionally permissible for this board.
But this board, I think, has always put in CRMC.
It will, to answer your
As a
question, Mr.
condition.
Chancesello, it would become a condition, if the board felt that the application could be approved, it would become an additional condition that the board's approval would be contingent on receiving the additional permits from the state agencies, in this case CRMC.
I'd just like to present Ms. Robbins. She's just,
Public hearing is closed, right?
well, she's a resident. I don't know.
Did we close the
Can I-
public hearing?
I
did
think
vote.
I'll
You
defer.
get a motion. You could vote to reopen it again.
Okay, can I have a motion to reopen the public hearing, please?
Move to open?
Second?
All in favor?
Aye.
Opposed?
Please raise your right hand. Do you solemnly swear the testimony you give in the matter now hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state and spell your full name for the record.
Jacqueline Morgan Robbins. Jacqueline, Morgan, Morgan, Robbins, Robbins.
Thank you.
There's a lot to this, and the legal part I can't speak to. The personal part I can. Don Coletti, our neighbor next door, he has stood up here and said things like, we did things on the sneak, we don't care about our neighbors. It's hard for me as a mom, as a Rhode Island native who married the military, moved around, to come back. My dream was to always have a home in Bonnet. Never thought growing up as a little girl that I would afford a home in Bonnet. We're not sneaky people. There is someone that is sneaky, and it's someone who has cameras on fences pointing in our driveway. It is someone who approached me in a dark driveway when I was sweeping in the middle of the night, 10:30 p.m. And I feared him. I don't know if there was drinking. The handshake, my knuckles were against his belly. It wasn't at the end of my driveway, it was in the deep part of my carport, my home. And I was begging my mother-in-law to come out, not my mom who's sitting here, my mother-in-law, to come out and know that I'm being spoken to and slightly threatened by my neighbor. I have lived in cities and have never felt that scared. The only thing in my vicinity while he was speaking to me in that carport, and I know he remembers it, was a golf club. And I picked it up and just pushed rocks around and stepped back as he continued to step forward towards me. I have never felt more nervous. And as a woman, knowing we rent to 3 women, college students, knowing that he has 3 or 4 cameras pointing down on our driveway, and he put up a fence between our homes that he never asked about a fence. He put it up and put cameras facing them. We get calls from them. I don't know if they sunbathe in that front yard. I don't know if they sit out on their deck. Is he listening to us? We are a military family. We do not deserve this. And this is just coming from a personal level, but I'm not going to stand here and let a man talk about my character and my family's character, call us sneaky and bad neighbors, and all the other things that were said about us. when that is not who we are. That is not who we are. Just because we haven't been around because we live in North Carolina does not mean we wouldn't come up to your door, shake your hands, and to do it on the sneak. How are we putting in egress windows on the sneak? How are we putting in driveways in the sneak? It's there. We're here. We flew in last night. My kids have been up since midnight. I'm not asking for it, but it's hard to listen to this and sit back and not have much to say. I wish you could take those cameras down. They make me incredibly nervous. They're not there for his safety. They're there to spy. It is creepy, and it's not neighborly. I know who I am. I know how I was raised. I know how I raised my kids. I know who I married. This is beyond the things that have been said. I agree, there's legal things, we have to do that, and we're here to make it right. But you're not going to take my character after you step forward towards me in a dark, dark driveway, my property. And that's all I have to say, because it's too much sometimes. But
Who are you talking about?
you.
Okay,
So
no,
I need a
no,
chance to come back
no.
up and speak.
No.
Because
No,
these are
no,
lies.
no.
We're
I
not
have to
here
sit down,
testify.
sir. No, it's not.
But I'm going to introduce myself to her. We had a nice
We
15-minute
need
conversation
to-
together.
You need to stop.
Stop. She's sitting here in
Sir,
front of everybody,
sir, please,
making lies.
Please, please. We will take that testimony for what we feel it's worth, so.
Thank you.
If I just have a question on 1223-2. Mr. Pimentel said there is no definition of single-family home, but it specifically says one of the requirements is that the project meets the definition of single-family home. So we're referencing a definition that doesn't exist?
Well,
is that right?
It doesn't exist in our ordinances. The state building code tells you exactly what.
Correct, right.
Okay.
And if there's no real definition in general, you can use
can
the
draw the
common
Okay.
definition as everyone, a reasonable person would believe it to be.
Okay.
So,
Do we have what that is? Does the board have what single-family home definition is?
we have not looked in Webster's or Merriam or anything like that, but I mean, I think everybody here has a definition in their minds of what single-family home is. I mean, we could go to the state building code and get a single-family definition if we really wanted to, but
the board is applying a definition that they don't know against an applicant.
I think I
And
know
I
what single
understand.
family is.
You want me to go, I can go to my office and grab the state building code and come back with the definition if you want.
If
I mean,
the
if it's
board
gonna
feels that
satisfy
that's
the needs of the
necessary.
board.
Yeah, I know, it's got 2 kitchens, but there are many homes that have 2
Yeah.
kitchens, but usually they're not rented out.
Right.
So,
That's the difference.
exactly, usually it's, a grandparents on below, a lot, but, if we were to move down, or if the applicant wanted to move down the path of an ADU, exploring an ADU, what would we have to do to this hearing so that we could we continue it with their blessing if that's what they wanted? And I'm gonna give them the option in a minute, I think, but what would we have to legally, procedurally do here?
Well, I'll explain this to the board.
Okay.
My job is not to give the applicant
Correct.
legal advice.
No,
But
I
I know
wanna know
they're
what
listening to me now.
Right.
To answer your question, it would appear as though that the board seems to be interested in whether an accessory dwelling unit, which is what we call an ADU, would be the more appropriate way to approach this.
Correct.
And if that were the case, then withdrawal or continuance would be appropriate, because a vote of no could result in a bar based factually for the next year.
Right. So, and a withdrawal, though, would require a new application.
Yes.
And new notice and new, all of that
So
stuff. 'Cause it-
the fairest thing, the best outcome from what I'm reading from the board tonight is that there be continued to a date that's appropriate to Attorney Ardente, so that he can consult with his client and put together an application. Have that presented to the building official and then bring it back before the board. And at that time, if he wishes to go through, he could withdraw his application that we're hearing right now.
And depending upon the plans of the ADU, this could be something that would be granted as of right without any.
By right,
by
yes.
right. Okay. With no zoning board necessary. Okay.
Yep.
Mr. Ardenti.
Can I consult with my client for a moment?
Sure. You can have more than a moment. Do we need a break?
No, we do.
Okay. Now, or something.
Don't they need a motion?
Move to close public comment.
Second?
All in favor?
Aye.
Thank you. Okay.
So we are going to go ahead, I had a chance to consult with my client and request a continuance, as the board has indicated, to be a potential option.
Okay. Can I have a motion to continue?
Motion to continue?
To what date?
Why, so we're continuing for,
For notice purposes, you should continue to a date certain, so
Okay.
you don't have to renotice again.
Correct. So the purpose of continuance is to give them a chance
to change
to
the,
figure out if they want to withdraw the applications or not.
And go with the ADO.
Yeah, and do something.
How much time, council, would you need?
Trying to think of this correctly.
Seems like February is already full.
Well, but what I'm thinking is if the purpose of the continuance would, well, if we could get on February, I think it would just be a vote at that point, right? Because everything has been solidified on the record.
I think you're right. There
So
will be no
I
need for
don't-
additional testimony.
Yeah, I don't know that having it on February, the agenda would beef up your agenda anymore, other than,
Yeah,
Are you
I
okay
would
with that?
concur with that
Okay.
assumption. I would feel comfortable with having that, given that the testimony has been closed and it will be solely for vote purposes.
Okay. So move to.
And you want February and is not January?
It would be February 9th. I would refrain from January. We have 3 appeals and multiple applications.
Okay.
So February 20th?
yes.
I think it's the
Oh,
19th.
19th.
Yeah, the date would be February 19th.
Okay.
Was there a second?
Second?
I'm sorry, Evelyn.
It's okay.
I didn't know if I missed
I didn't
it.
know if someone was going to repeat the motion
Oh.
with the date certain,
I
so.
thought I missed the second.
So it is with the date certain, so.
Yes.
Second, anybody?
Second?
So just to be clear for the record, I have a motion by David Trenasow, seconded by Karen Coutinho, to continue to a date certain of February 19th, 2026.
Yes.
Thank you.
All in favor?
Aye.
Opposed?
Thank you, members of the board.
Thank you. Okay. Next item, KSN LLC.
Thank you.
I'm Katie Buchadlo. I'm sorry. You solemnly swear the testimony you give in the matter now I'm hearing will be the truth, the whole truth, and nothing but the truth. So if you guys please state and spell your full name. Katie Buchadlo, KatieWerchadlo.
Katie, could I start though by, I think what we have is a possible notice issue. So could you tell us the notice that was given to abutters, and there's an affidavit that you filed that says that you gave a notice, it says not more than 10 days. State law requires 14.
Yes.
So this is.
So I actually gave 17 days notice because I got the form from Amanda on October 7th and I mailed those the same day. which was
Okay,
17
so
days.
is that enough?
I would just like to confirm with our legal advisor that that is appropriate.
Is that enough that the testimony, she just testified that she gave the notice on, what was the date again?
October 7th.
October 7th.
Based on the notice of 10 days, which is incorrect, everything is fine there, it was notarized, etc. The testimony from this individual just says it was really put in the mail 7 days earlier. So that's sufficient for the board to
Sufficient for
have
the board
met
to hear it.
notice
Okay.
requirements.
Okay, great. Okay. Go ahead.
So I'm Katie Buchadlo from KSN LLC. The property is 3 Glenroy Drive. That is it, yeah. So these front entry stairs, as pictured, were there when I purchased the property. And in the last year or so, they were really starting to come away from the house. There was a big gap. There was some rotting to it, so it was becoming a safety issue. The intent was to replace the stairs exactly as they were so that there wouldn't be any change. My contractor that I had hired redrew that plan and submitted it, but I guess it was a handwritten plan, so there were some issues to that. So I hired a surveyor to come out and obviously create this plan. This is the proposed. And unbeknownst to me, the contractor got started before the permit was officially issued, so you will see a existing and a new proposed. And so I have looked for a different contractor, just full disclosure, because that created this big issue. And the reason that we had to make the landing a little bit larger is because the utility line, the gas line, goes directly under where the existing footing was, and when we demolished the pre-existing stairs, we found that they were not cemented in at all. They were just placed on top of the ground, and my assumption is that that's because they couldn't dig down because they knew that or saw that the high-pressure gas line was there. So it has to be moved back to what is proposed here, and that's why I'm asking for the variance so that we can avoid the utility line, because otherwise I would have just used the existing area. And these are front door stairs, so when this is the driveway, and then this is the landing to go into the stairs, so those are the front doors.
Katie, I assume DeepSafe verified that that's where the gas line is?
You have to speak your answer.
Oh, sorry, yes.
So are you you're making the stairs go further from left to right on the front of the house?
So the stairs themselves will be just like the other, it's the landing that had to come out, because this footing here is where the gas line was going to have a conflict. So the actual stairs themselves over here are the same, but this had to come out an additional several feet to accommodate the line underneath, so that the footing could be grounded into code, because the prior footing was just placed on top of the ground, and I obviously didn't know that until we went to demo. So unfortunately, none of the existing stairs appeared to be conforming with any code, which is problematic.
Can we see the slide before?
Sure.
So on that one right there, can you show where the gas line is?
Yeah, my surveyor made.
It's right here.
Okay, yeah. See this line there? So now this footing comes out so that it avoids it, because the existing footing was going to be contracting or coming into contact with it. So it's very, very light, but that's the line. So, and that's why this footing came out, to give it clearance.
Can you comment on why the planning board might have denied this?
So I didn't get to go to the planning board by myself. I did send a representative. So I've mentioned to Heidi, I have a sick family member at home, so just getting here is, a challenge. So I did try to send somebody that I thought would be able to answer questions on my behalf, but I found that was not the solution. So I did make arrangements to get myself here today, but I think that they just didn't have all the answers that they were looking for at that time.
This project is not in compliance with the development and performance standards of section 18.5.
Determination of
Number 3, prior to the issuance of a building permit, the applicant will submit comprehensive information contained in the agreements to deny them.
Is it possible to make the deck smaller so you're not encroaching further into a larger setback issue? Like, is it possible to have that footing in closer, or?
It was only 3 feet out to begin with, so I I don't know that you could really have proper structure at, you know, like 2.5 feet, and the way, so, this is the existing post, if you can tell, it was about halfway back here, so I'm not sure that we would even have room to clear the gas line.
Yeah.
My surveyor drew this up for me, you know, as a way to show, you know, why we had to go where we went.
Mhm. Okay. Wayne, are there minimums for a platform like that before you're entering a house on threshold?
It would have to be at least 3 feet in depth at a minimum for code. And the width of the door, whatever the door width is, it has to be that width as well.
Okay.
Those are the 2 criteria.
And that 3 feet is what it was previously, but it just was never cemented down. So it was just kind of floating on top of the
Does
ground.
staff know why planning might have denied this?
Based off of their reasoning, Mr. Callahan, I believe, made the motion. They denied it based off of it not being compatible with any of the development standards. They did not specifically address a specific numbered criteria in section 18.5. However, he did specifically mention the word any. So presuming all portions of 18.5 standards 1 through 16.
I'm having a hard time finding which one it violates. I'm really.
I don't want to put words in the planning board's mouth that weren't my own.
If you go through them, I can't see one that is violating.
Also, Mr. Trennis, to your confusion, your staff report doesn't actually specifically include, or your reference.
I have my other
okay,
book.
I see. Yeah.
Right.
If I may, I think the planning
On
board
whose
would
action?
accept that, you know, we didn't come back to the planning board when we went to the zoning board, because, you know, we had the final jurisdiction over it. I think that could have some part of it.
So the only relief is for dimensional?
Yes, that is correct. They're asking for 11.4 feet for a front yard setback variance.
Any other questions?
No.
Is there anyone, close the public hearing. Is there anyone here that wishes to speak in favor of the project? Against? Anyone? No, no one here, okay. And a motion to close the public hearing.
Motion to close public hearing?
Second?
All in favor?
Aye.
Aye. Aye. Okay. Who's got this?
Wow, I think I have. So I think finding of facts, because of the gas line, the applicant is required to move the footing, or the placement of the footing, which therefore would look for the 11.4 front yard setback. Gas line has been verified by DeepSafe. I don't think there's any other facts that I can think of.
You want to accept the findings of fact as
Accept the
project
finding of
summary?
facts of the project summary.
Ms. Secretary, I'd like to confirm, is this a motion to enter the findings?
Motion to enter the findings of fact.
Okay.
Sorry, first one.
No, that's okay. So yeah,
Second? Second. Second.
would you like to specify the findings of fact A through F being included in your findings, that those would be
Yes.
included?
Yes, thank you.
We have a motion and a second. Did we all vote in favor?
Aye.
Aye. Okay. What is your pleasure?
I move to grant the 11.4 front yard setback. So move.
I second
No, Ms. Secretary, would you like to include the conditions that were set
conditions.
forth in the conditions
Right.
1 through 3 in that approval.
Yes, and conditions 1 through 3 also be included in the final motion.
So we have a motion to approve the requested variance and with the conditions 1 through 3 as noted in the project summary. Do we have a second?
Second.
All in favor?
Aye.
Thank you.
Thank you.
Done. And Mr. Gonzalez for- Thank you.
You're welcome.
I don't think Pelosi is here.
No. So, item D5, the Pelosi's application, similar to the concerns that were brought for this applicant, there was a defect that was noticed in the butter notification, and the town has advised the applicant that their item will be continued to next month's meeting, so that way the applicant can re-notify and make sure that that notice is properly sent out in the correct time period of 14 days.
Thank you. So we are not, there's no continuance necessary. We're not continuing.
Continue to a date certain?
Continue to a date certain, is that?
I think it's to continue it to January 19th.
Yes.
Okay.
And that would satisfy the public notice which is being broadcast around that this application called Pelosi will be heard on January 19th when
Okay.
it gets proper notice.
I have a motion to continue Pelosi to a date certain of January 19th.
So moved.
Second.
All in favor?
Aye.
Great. Thank you. Do we have any reports from staff or the solicitor or anybody?
Ms. Secretary, I need a motion to continue the November minutes. They're not available yet.
Okay. May I have a motion to continue the
Motion
November
to
minutes?
continue the approval of the minutes to
January
January
22nd.
22nd. Second.
All in favor?
Thank
Aye.
you.
I guess the next thing is motion to adjourn.
Move to adjourn. Second.
All in favor?
Aye.
Thank you.